Good morning. My name is Bevan Lawrence. I'm the chair of the next session. I'm a West Australian and have been on the board since the inception of the Society and still haven't quite retired from it. It's my pleasure to introduce His Honour the Chief Justice of Western Australia, Mr Wayne Martin, to you this morning. His Honour graduated from University of Western Australia with first-class honours in 1973. At the age of 41, he was made a QC in 1993. He was President of the Bar Association of Western Australia for 3 years, Chair of the Law Reform Council of WA for 5 years, and also served as President of the Law Society of WA and was Director of the Law Council of Australia for 1 year. He was elevated to the bench, straight to the Office of Chief Justice in 2006, and he was appointed Companion of the General Division of the Order of Australia in 2012. They're the basic details, but the real information about him is that in 1980, when I was acting for some Korean immigrants, and he was working in the Department of Immigration in Canberra, he kindly gave them certain advice which led to them not proceeding with a deportation order against my clients, and I can advise you that His Honour can rest happy that they're now good, honest, law-abiding citizens of Australia, and I see them from time to time. He's also served in many volunteer positions throughout the community, and my wife tells me he was an outstanding chair when she served under him on the council of our local primary school. In 1990, he became an unwitting political activist. At that time, several of us here in Perth were trying to force a Royal Commission into the activities of the Burke and Dowding governments, and we came across the idea that if we get enough lawyers to sign a petition, God knows why we thought that we might be able to persuade the government to call the Royal Commission. In any event, we called a meeting. We got 90 lawyers in the one room. We got them all to sign the document. We published it in the WA newspaper, and we appointed His Honour as chairman of our group and had the illustrious title of the WA Constitutional Law Group. And on the 20th of August 1990, His Honour, then merely Wayne Martin lawyer, called for a full and open inquiry into the WA government, and within 3 months the government had folded and called the inquiry. More importantly, he's a parent of one of the children in our hockey club who's played with us for many years. Ladies and gentlemen, I'm obsessed with hockey, by the way. Ladies and gentlemen, I give you His Honour the Chief Justice of Western Australia, the Honourable Wayne Martin AC. Thank you.
Thank you very much, Bevan, for that very kind introduction, which has characteristically significantly understated your role in those events of 1990. It's a very great honour for me to have been invited to address this conference, organised by a society which is named in honour of the man who was, of course, the first Chief Justice of Australia and also very influential in the formation of the Constitution of our nation. As we'll see, Sir Samuel proposed the two provisions in that Constitution which referred to Aboriginal people and which were amended by a referendum held 50 years ago this year. Those amendments gave rise to concurrent state and federal responsibility for laws and policies relating to Aboriginal people, which is the topic of my paper. Because that is my topic, it's more than usually appropriate for me to commence, as I always do, by acknowledging the traditional owners of the lands on which we meet, the Whadjuk people who form part of the great Noongar clan of southwestern Australia, and I pay my respects to their elders past and present. 2017 is a significant year in a number of respects. It marks, as I've already noted, the 50th year of the 50th anniversary of the 1967 referendum, the 25th anniversary of the decision of the High Court in Mabo, which recognised native title. It's the 20th anniversary of the publication of Bring Them Home, dealing with the so-called stolen generation. More controversially, perhaps, it's also the 10th anniversary of the Commonwealth intervention in Aboriginal affairs in the Northern Territory. And while different views are held with respect to the desirability of that step on any view, it was a significant development in relation to intergovernmental relationships with respect to Aboriginal people in Australia. Those anniversaries, I think, need to be placed in a broader temporal context, as do the 100 years or so since Federation and the 200 years or so since colonisation, and in a context in which earlier this year we were told that there is rock art in the Northern Territory which is at least 65,000 years old. By contrast, the rock art in the famous rock art in the caves of Lascaux in France is 17,000 years old, and the oldest known rock art in Europe is 35,000 years old. The last ice age ended just about 12,000 years ago, and the first known use of the wheel was about 5,000 years ago. So to put a cultural grouping that's 65,000 years old into that context, I think placed a significant onus upon the colonists in relation to the respect and appropriate treatment of that cultural grouping. 2017 is also the 110th anniversary of a less well-known event, which is the death of a Noongar woman, Fanny Balbook Uriel. With the indecent haste to declare the Aboriginal people a dying race evidenced in other parts of Australia, Daisy Bates described Balbook as the last Perth woman. She might more accurately have been described as an early Aboriginal land rights activist because, as Bates described, throughout her life she raged and stormed at the usurpation of her traditional grounds. She was known to stand at the gates of Government House, just along the terrace from here, reviling all who dwelt within, because the stone gates guarded the burial place of her grandmother. She was born on Harrison Island, which some of you may have passed over when you came into the city from the airport. It now is the base of the causeway that links the two sides of the river. She lived on the causeway, and there was a traditional track from that area where she and others lived to a swamp about where Perth Railway Station now stands, where Aboriginal women gathered jilgies, which are small freshwater crayfish, and vegetable food. The track passed very close to where we now are, as you can see from that map. When a house was built on the path, she broke its fence with a digging stick and charged up the steps and through the rooms, and she was in the habit of breaking down fences. She was, of course, seen by the colonists as an annoying nuisance, but with the benefit of hindsight, we can see her perhaps as an early activist for recognition of the traditional rights of the original inhabitants of this land. As our last keynote speaker pointed out, the Australian Constitution is not a rights-based constitution. It's not about the rights that the citizens enjoy as against the government which it formed. Rather, as Professor George Williams has observed, the Constitution is more about the polygamous marriage of the colonies and the powers of their progeny, the Commonwealth, than it is about the relationship between the citizens and the newly formed government. In that context, it's perhaps not surprising that Aboriginal people were only mentioned twice in the Constitution as originally enacted, and of course since the 1967 referendum they are not mentioned at all. The two occasions upon which they are mentioned are Placidum 26 of Section 51, the race's power, which provides that the Commonwealth can legislate with respect to the people of any race, as originally enacted, other than the Aboriginal race in any state, for whom it's deemed necessary to make special laws. And Section 127 provided that in reckoning the numbers of the people of the Commonwealth or of a state or other part of the Commonwealth, Aboriginal natives shall not be counted. Now, as we'll see, the original framers of the Constitution had in mind that the race's power would be used by the Commonwealth Parliament to discriminate adversely against people of a particular race. Members of the Aboriginal race were not excluded from that power for the purpose of protecting them from adverse Commonwealth discrimination, but to ensure that the states were empowered to continue to legislate adversely against Aboriginal people without interference from the Commonwealth. And consistently with that approach, Section 25 of the Constitution continues to provide that if any law of any state disqualifies persons of any race from voting, members of that race resident in that state are not to be counted for the purpose of reckoning the number of the people of the state or of the Commonwealth. Now, those provisions were, and Section 25 remains, indubitably racist. As Professor Williams has pointed out, Edmund Barton, who was, of course, later to become Australia's first Prime Minister and also a member of the High Court, stated at the 1898 Convention that the race's power was necessary to enable the Commonwealth to regulate, and I quote, to regulate the affairs of the people of coloured or inferior races who are in the Commonwealth. The first edition of Quick and Garran described the race's power in the following terms: it enabled the Parliament to deal with the people of any alien race after they've entered the Commonwealth, to localise them within defined areas, to restrict their migration, to confine them to certain occupations, or to give them special protection and secure their return after a certain period to the country whence they came. And so in that context, it's hardly surprising that the Australian Constitution, not being a right-based constitution, doesn't contain the equal protection provisions that are seen in some other constitutions, notably that of the United States, a provision to that effect having been promoted by Inglis Clark, the Attorney General of Tasmania, but roundly defeated at the conventions at which it was proposed. Professor Saw has expressed surprise that the position of Aboriginal people was scarcely mentioned during the constitutional conventions. In 1966, he wrote in these terms, "Today it may seem shocking that the federal conferences and the conventions of 1890, 1891 and 1897-8 should have paid so little attention to the position of Aboriginal people. It's not merely that the founders treated Aboriginal questions as a matter for the states. What is surprising is that the position of the Aborigines was never even mentioned." Professor Saw goes on to cite evidence given to the Royal Commission on the Constitution in the late 20s by the infamous A.O. Neville, who was the Chief Protector of Aborigines in Western Australia, and some of you may have seen him depicted in the film Rabbit Proof Fence. Neville attributed the indifference of the framers of the Constitution to two things. Firstly, the lack of any reliable count of the Aboriginal population, and secondly, the widespread view that Aboriginal people were a dying race whose future was unimportant. Whether or not those views are accurate or not, it seems clear that the laws as originally framed and the constitutional provisions were enacted for the purpose of ensuring that the states retained power to legislate adversely with respect to Aboriginal people. Sir Samuel Griffith was responsible for both of the provisions which named Aboriginal people in the Constitution. The race's power came to be known as Sir Samuel Griffith's Clause. He was described as having a special knowledge of the matter, and it was he who proposed the inclusion of section 127. The mood of the time, perhaps the zeitgeist if you want, was exemplified by Sir John Forrest, who was then Premier of Western Australia, who was unabashed in the expression of the desire that the states retain power to legislate with respect to the race's power. At a time in the conventions when it was proposed that the race's power be an exclusive power of the Commonwealth, Sir John railed against that, asserting that, in his opinion, the control of the people, of whatever the colour they are, of whatever nationality they are, living in a state should be in control of the state. For that reason, he opposed exclusivity. He relied upon the laws of Western Australia to support that proposition, observing that we've made a law that no Asiatic or African alien can get as miner's right or do any gold mining. Does the convention wish to take that away from us? Now, interestingly, another law that had been passed by the Parliament of Western Australia was the Immigration Restriction Test Act of 1897, which was the early precursor of the dictation test. That was a law that was passed regulating entry into Western Australia based on legislation from Natal in Africa, designed to overcome the risk of legislation framed on racist grounds being disallowed by the Parliament in Westminster. So instead of overtly discriminating against people of a particular race, it regulated entry on the basis of capacity to complete a dictation test when requested to do so by an officer. But there was a problem in the Western Australian legislation because it expressly provided that it didn't apply to any person of a class for whose immigration into Western Australia special provision had been made by another law. And the Chinese Immigration Restriction Act of 1889 was such a law. It provided that ships could lawfully bring into Western Australia one Chinese passenger for each 500 tonnes of its registered tonnage. So it was a kind of a ratio between tonnage and the number of Chinese you could bring in. That law remained in force, so 10 years later in 1899, when two Chinese men who'd sailed to Cossack, which is an old port in the north of the state, on the SS Karrakatta, failed the dictation test, the charges of illegal entry brought against them failed because they were people for whom specific provision had been made by another act. Now, of course, the Commonwealth followed that legislation after its creation and adopted the dictation test itself. And of course, we all know of the famous story of Egon Kisch, who was the socialist activist with a valid visa for entry, who was desired to oppose his entry, so they administered the dictation test in Scottish Gaelic. The High Court held that that was not in accordance with the legislation, but that's another story. Let me get back to the topic that I'm supposed to be addressing. In relation to the race's power, Placidum 26 of section 51 Professor Sora described its origins in these terms. He said it was intended to enable the Commonwealth to pass the sort of laws which before 1900 had been passed by many states, concerning the Indian, Afghan and Syrian hawkers, the Chinese miners, laundrymen, market gardeners and furniture manufacturers, the Japanese settlers, the Kanaka plantation labourers of Queensland and the various coloured races employed in pearl fisheries in Queensland and Western Australia. Now, given that context and the history of the state legislation which I've exampled in Western Australia, it's, I think, abundantly clear that the exemption of Aboriginal people from the non-exclusive legislative power conferred upon the Commonwealth under Placidum 26 of Section 51 was not done for the purpose of exempting Aboriginal people from discriminatory laws to be passed by the Commonwealth, but was done for the purpose of ensuring that laws passed by the states discriminating against Aboriginal people were not jeopardised by inconsistent Commonwealth legislation and the operation of Section 109 of the Constitution. And so the parliaments of the states remained free to introduce laws with respect to Aboriginal people, and in Western Australia that was done, for example, in 1905 by the Aborigines Act, which in effect introduced a system of apartheid into Western Australia, based heavily on the laws passed in South Africa, introducing that same policy. The origins of Section 127 are more obscure. It seems clear that it was intended to exclude Aboriginal people from calculations made for the purpose of distributing funds and apportioning parliamentary seats, but it came to be regarded as a qualification on the census and statistics power contained in Placidum 11 of Section 51, a power which I think will receive renewed attention in the coming month or so. There was no definition of Aboriginal natives for the purposes of Section 127, and ultimately the Bureau of Census construed the expression as being limited to full-blood Aboriginal people and as not including Torres Strait Islanders. Now, I've mentioned that both of these provisions were promoted by Sir Samuel Griffith, but that should not lead to the conclusion that he was sympathetic to the more extreme anti-Aboriginal sentiments of the day. To the contrary, he was seen as a supporter of the advancement of Aboriginal people. As a politician in Queensland, he had actively promoted moves to ensure that the evidence of Aboriginal witnesses was admitted in legal proceedings. Later, as Chief Justice of Queensland, he directed a jury to treat the evidence of an Aboriginal witness with equal weight and respect as the evidence of any other. And a biographer of the day notes that a press report included him with so-called black sympathisers. Now, of course, the laws were passed in that form in 1901, and as I've mentioned, the states were then free to legislate in the manner in which they had without Commonwealth interference until 1967. The signs of community change are evident in the early 60s. In 1961, the Federal Conference of the ALP, at the instigation of Mr. Kim Beazley Sr., resolved that Section 127 and the exclusion of Aboriginal people from the races power should be deleted from the Constitution. A bill to that effect was introduced in the Commonwealth Parliament by Mr. Caldwell. That bill lapsed. Other bills proposing changes to those provisions were introduced by Prime Minister Menzies and by the relevant minister, Mr. William Charles Wentworth, in 1966. Both of those bills passed the House and both houses, but neither went to a referendum. In the meantime, there'd been other significant developments. In 1962, of course, the Commonwealth Electoral Act was amended to provide universal adult suffrage to Aboriginal people. In 1963, the famous bark petition from Yerkala was presented to the Commonwealth Parliament, and in April 1966, the Gurindji people famously went on strike and walked off Wave Hill in protest of their treatment. And it's in that context that in 1967, Prime Minister Harold Holt introduced a bill which proposed the removal of the words "other than the Aboriginal race in any state" from Placidum 26 of Section 51 and the deletion of Section 127. The bill was supported by all sides of politics and passed through the Parliament without controversy. And because of that consensus, the only information supplied to voters was information in support of a yes vote. That vote achieved 91.8% support in the referendum that was held, and that is the largest majority in favour of any referendum ever put to the Australian people. There is, of course, a question as to whether the races power includes power to legislate adversely for the people of any race. While that is certainly its historical origin, it is, I think, questionable as to whether it is to be construed in that way today. That question arose and came before the High Court in the Hindmarsh Island Bridge case, the Cartonieri case. Two members of the court Justices Gummow and Hayne concluded that the power did extend to laws adverse to the people of any race. Justice Kirby disagreed. Justice Gaudron took a rather more nuanced approach, but I think it's clear that she was also more inclined to the view that it didn't support legislation adverse to people of any particular race. So the High Court seems to be split on that question, which must, I think, be regarded as open. What is, however, clear, though, since 1967 is that the Commonwealth has used the race's power to legislate extensively with respect to Aboriginal people and has applied very significant resources, both financial and administrative, to the task of improving the living conditions of Aboriginal people. That general objective is often, of course, described by the catchphrase "closing the gap," which refers to the significant gap between the health living conditions of circumstances of Aboriginal people in Australia and the circumstances of non-Aboriginal people. Statistics identifying the gap in a number of specified areas are published annually by the Commonwealth Government, consistently with a formal commitment made by all Australian governments to endeavour to achieve health equality within 25 years. The latest report card shows that we are failing to close the gap in 6 out of the 7 key indicators measured. In relation to life expectancy, Aboriginal people die about 10 years younger than non-Indigenous Australians. In relation to child mortality, there's been no significant decline in Aboriginal child mortality since 2008. In relation to employment, the Indigenous employment rate has fallen since 2008 rather than increased. In relation to reading and numeracy targets, halving the gap between non-Aboriginal children and Aboriginal children, only Year 9 numeracy is on track in relation to all the areas being measured. In relation to school attendance, there's been no meaningful change in Indigenous school attendance rates between 2014 and 2016. In relation to early education, there has again been no significant change, and indeed access for Indigenous 4-year-olds in remote communities was a target that wasn't met in 2013. The only good news is in relation to Year 12 attainment, where we are on track to meet the goal by 2020, but of course Year 12 attainment is still significantly lower for Indigenous students than it is for non-Indigenous. In 2014, 61.5% of Indigenous students finished Year 12 compared to 86.4% of non-Indigenous students. The gross overrepresentation of Aboriginal people in the courts and prisons of Australia isn't measured in the closing gap statistics. That's been controversial. If it was included in the closing the gap statistics, the gloomy picture presented by those statistics would be even gloomier because, for example, since the presentation of the Royal Commission report into Aboriginal deaths in custody in 1991, the overrepresentation in prisons has almost doubled. So why are we failing? Why are we not closing the gap, despite the fact that there are both branches of government, both federal and state government, have responsibility in these areas and significant resources are being applied? That is a very complex question, which is beyond the scope of this paper, which is really restricted to analysing the extent to which the diffusion of ultimate responsibility between the Commonwealth Government on the one hand and the state and territory governments on the other hand has impacted upon our policy performances in these areas. Recently, there was a very interesting paper produced by the Indigenous Affairs Group within the Department of the Prime Minister and Cabinet, and that identified two recurrent underlying problems which are said to have characterised Commonwealth public policy in respect of administration relating to Aboriginal people over the last 50 years. They are whether and if so how to achieve the representation of Aboriginal and Torres Strait Islander people in the decision-making process, and how best, second problem is how best to organise the machinery of government to maximise positive results. The first issue relating to representation of Aboriginal people is of course topical as a result of recommendations made by the recent Uluru Conference. They are of a political character and therefore it'd be unwise for a serving judge to trespass into that area. Issues with respect to machinery of government are a little more prosaic and I think safer ground for me to traverse. The same paper to which I've referred has reviewed Commonwealth administration and made a report that Commonwealth administration of Aboriginal affairs over the last 50 years has been extremely volatile and characterised by frequent structural change. As the report points out, there have been more than 10 different organisational structures for delivery of Commonwealth policy relating to Aboriginal issues, 21 different ministers over the 50 years. 9 of those 10 organisational structures occurred within the last 30 years. By contrast, in America, the Federal Bureau of Indian Affairs has been in existence since 1849. Structural volatility in the machinery of government is not limited to Commonwealth. Looking parochially at Western Australia, there have been 14 ministers for Aboriginal affairs, even though there was no minister with responsibility for such matters over 12 of the last 50 years. Since 1967 in WA, there have been 6 different administrative agencies, with 4 over the last 20 years. Now, again, the consequences of these frequent changes in structure at both state and federal level have been, I think, very well described by the group within the Prime Minister's Department to which I referred. Those changes have adverse impacts on relationships of trust and good faith, which can take many years to build across cultures, the cultures of the non-Aboriginal and Aboriginal people. As they observe, new policy requires a long trail of internal alignment from the government through the bureaucracy and onto staff engaged with Aboriginal and Torres Strait Islander communities. Explaining constant changes in ways that maintain confidence takes great skill. It takes time for officials to reconfigure narratives and develop an approach that will keep faith with community. Changes in the machinery can lead to extensive loss of corporate memory, resulting in old ideas being circulated again and again without the knowledge or evaluation. And that recycling has led to a deep sense of here we go again and cynicism amongst many Aboriginal and Torres Strait Islanders. The other point made by the group is that the frequent changes to which I've referred create a burden of knowledge transfer, and that burden has in the past often been shouldered by Aboriginal and Torres Strait Islander communities, who are the repositories of continuing knowledge in this area rather than government. Now, because I don't know a great deal about administration of Aboriginal affairs, I consulted the Honourable Fred Chaney, AO, who was, of course, one of the 21 Commonwealth ministers to which I've referred, and he was good enough to refer me to a number of materials in the field. They were quite depressing in relation to the efficacy of Commonwealth Government administration in this area. As he wrote, there have been regular concerns about failures in Aboriginal-controlled service delivery organisations, including complaints of maladministration, nepotism and sometimes corruption, although he points out that the consequence of those failures have drowned out the efforts of the rest. And if he assumed, he did a statistical analysis and assumed that if 1 in 10 of the Aboriginal organisations that were funded were defective, which would actually be quite a good success rate for small business success within the community. Nevertheless, that failure would result in a scandal every working day of the life of the government, for the media to report and for the government to try and defend. He cites other authors who have described government funding arrangements as having reinforced community and organisational dysfunction. So the question is, why is it that governments have found it easier to ignore systemic failure while continuing to promote worn-out policy approaches that have been unworkable, proven themselves to be unworkable? Again, Fred Chaney has pointed out that a steering committee promulgated by the Productivity Commission, of course an expert body of economists, has identified 4 preconditions to policy success in this area, and they are, firstly, cooperative approaches between Indigenous people and government, often with non-profit and private sectors as well, community involvement in program design and decision making, a bottom-up rather than a top-down approach, good government at organisation, community and government levels, and ongoing government support, including human, financial and physical resources. Now that seems to me to be a very prudent list of criteria for success, and I don't doubt its significance, but what I do doubt is the capacity for those preconditions to be met in a governance structure which involves 3 levels of government: local government, state or territory and federal government, in the development of policy and the delivery of programs. Unless all of those levels of government act consistently and coherently and speak with one voice in the short, the medium and the long term, these conditions, criteria for success, will remain a distant chimera in the far horizon. Other points made by Fred Chaney include the fact that programs must be conceived, developed and delivered at a regional and local level. And again, that becomes more difficult, I think, when you have 3 levels of government involved, both local, state, territory and federal. So when, for example, critical decisions with respect to Aboriginal people in the Kimberley continue to be made by people many thousands of kilometres away in either Perth or Canberra, who may have limited experience of those conditions, those decisions are unlikely to respond effectively to the particular needs and interests of the people in that region. Cheney also proposes that iterative program development is very important. You need an incremental process of looking at policies that work and then advancing them. Again, that becomes more difficult to achieve if you've got 3 levels of government involved in delivery. Proper legal frameworks is another key point made by Fred. He says you need a proper legal framework, again made more difficult if you've got at least 2 areas legislating with respect to the legal framework for delivery of these policies. Silo-based policies from both state and federal governments has been the subject of criticism at crescendo level for decades now, and there are lots of papers referring to the difficulties which silo-based policy delivery has for Aboriginal people in remote and regional Australia. The problem, of course, under our current system is that there are 2 groups of silos. There's the state-based silos and the federal-based silos, which exacerbate those situations. Commonwealth programs have been criticised by Cheney. He describes it as 1-year funding, often, with no continuity guaranteed, onerous and costly reporting requirements, frequent policy changes, lengthy negotiations about working to shared objectives that are dropped without apology or explanation because priorities or policies have changed. Now, if that's right, if it is difficult for the Commonwealth departments with some responsibility for health, housing and education of Aboriginal people to work consolidatively, cooperatively and collaboratively with each other and with Aboriginal people in regional and remote communities, how much harder must it be for those agencies to work in conjunction with the corresponding agencies of the relevant state or territory government to achieve the same objectives? Now, regrettably, I don't pretend to have a simple or ready answer to the conundrum presented by this analysis. Indeed, if there was a simple and ready answer, I suspect somebody would have found it in the last 50 years, in which there has been goodwill and a lot of resources applied to this problem, but without conspicuous success. Regrettably, they have, as I've mentioned, the recent decades have been characterised by a failure to close the gap in almost all the key areas indicated. Turning to the states and territories, under current constitutional arrangements, of course the state and territories have primary responsibility for the delivery of health, housing, education and justice services. If Aboriginal disadvantage is to be addressed successfully, it must be addressed in these key areas. So any attempt by the Commonwealth to duplicate delivery of primary services in these areas would be extremely inefficient and wasteful. So it follows that the states and territories must remain key players in developing the legal structures, the policies and the programs required to close the gap. Ideally, the states and territories will create structures which will enable devolution of responsibility for such matters to regional and locally based decision makers working in close cooperation and collaboration with the Aboriginal people in the communities which are to be affected by the policies and programs ideally delivered also by Aboriginal organisations and entities. Nor, of course, turning to the Commonwealth, nor should the Commonwealth contemplate withdrawal from the field. 50 years ago, more than 90% of those voting in a referendum supported amendment of the Constitution to provide the Commonwealth with legislative power relating to Aboriginal people. And under current fiscal arrangements, the provision of financial resources from the Commonwealth will be an essential component of the programs required to address the level of disadvantage currently experienced by too many Aboriginal Australians. So where to now? If all levels of government must remain involved in the development of policies and programs in this area, and I think that seems clear, how do we avoid the pitfalls of the past? The risk of sounding like an ageing male Pollyanna, the level of public support for success in this area, a level of support which I believe crosses political boundaries, should provide fertile ground both state and territory level and to enable the states and territories to cooperate and collaborate with the Commonwealth Government at a level which has been unprecedented in our federation outside times of war. I don't believe, nor would I accept the proposition that it's beyond human wit and ingenuity to devise an intergovernmental structure which would facilitate the achievement of the various preconditions and imperatives for policy success which have been identified by those with expertise in this area and which I've endeavoured to mention. I don't underestimate the difficulty of designing and implementing effective systems of intergovernmental action in this area, given the historical volatility of changes in personnel and policy which have bedevilled this area of public administration. But those problems must be overcome if contemporary Australia is to provide the sorts of policy changes and programs that will redress the effect which colonisation has had upon one of the largest unbroken cultures on our planet. Thank you very much for your attention. I'll be happy now to take some questions.